Hello everyone, I'm Debojit Das and welcome to Courts Today, your daily roundup of everything of significance from India's top courts. So, let's begin. Our first story takes us to the Delhi High Court, where a fresh petition has been filed seeking the removal or at least the relocation of the graves of Afzal Guru and Maqbool Bhatt from Tihar jail. The petition comes from the Vishwa Vedic Sanatan Sangh, which argues that keeping their mortal remains inside a state-controlled prison is both illegal and unconstitutional. The core of the argument rests on the Delhi prison rules of 2018. These rules require that the bodies of executed prisoners be disposed of in a way that prevents their glorification and ensures prison discipline and public order. The petition says that by burying Guru and Bhatt inside Tihar, the authorities have effectively allowed the prison to turn into a potential site of pilgrimage for extremist elements. To prevent this, it asks the court to either remove the graves altogether or, if that is not possible, shift the remains to a secret location. The case has clear historical weight. Muhammad Maqbool Bhatt, co-founder of the Jammu Kashmir Liberation Front, was executed in 1984 and buried in Tihar. Afzal Guru, convicted in the 2001 Parliament attack case, met the same fate in 2013. In his plea, the petitioner compares this with cases like Ajmal Kasab and Yaqub Memon, whose burials were deliberately handled in ways to avoid any possibility of glorification. The questions now before the court are both legal and moral. Does housing these graves inside Tihar undermine constitutional principles and public order? Can the state balance the dignity owed to the dead with the need to prevent misuse of their memory? And if removal is ordered, what precedent does it set for future high-profile cases? These are the debates the Delhi High Court will now have to navigate, and the outcome could set a fascinating precedent. Next, it seems like the long wait will finally be over, as the Supreme Court of India has issued a notice on the bail plea of former JNU scholar and activist Umar Khalid, who has been in custody since September 2020. Khalid is one of the accused in the alleged larger conspiracy behind the 2020 Northeast Delhi riots, facing charges under the Unlawful Activities Prevention Act. The bench, comprising Justices Arvind Kumar and N.V. Anjaria, deferred the hearing of the bail pleas filed by Khalid and others, including Sharjeel Imam, Miran Haider, and Gulfisha Fatima, to October 7, 2025. Senior advocate Kapil Sibal, representing Khalid, emphasized the need for a timely hearing, stating, before Diwali so that they can be out by Diwali. The Supreme Court's intervention comes after the Delhi High Court that previously declined bail to Khalid, leading him to approach the apex court. The case has garnered significant attention, with debates surrounding the application of UAPA and its implications on individual freedoms. The upcoming hearing on October 7th is expected to be pivotal in determining the course of legal proceedings for Khalid and his co-accused. Next up, in a high-profile financial case, the Supreme Court of India has dismissed Bollywood actress Jacqueline Fernandez's plea to quash a 200 crore money laundering case linked to alleged conman Sukesh Chandrasekhar. The Enforcement Directorate had named Fernandez as the 10th accused in this case, which involves allegations of extortion and money laundering. Senior advocate Mukul Rohatgi, representing Fernandez, argued that she was unaware of the illicit nature of the gifts she received from Chandrasekhar and contended that she should not be implicated without clear evidence of her involvement in the alleged crimes. However, the Supreme Court bench, comprising Justices Dipankar Datta and A.G. Masih, referred to the precedent set in the Vijay Madan Lal Chaudhary case, which upheld the constitutionality of various provisions of the Prevention of Money Laundering Act. The bench emphasized that at the stage of framing charges, the court must accept the allegations as they are, and noted that the law allows for the possibility of individuals being implicated in money laundering cases, even if they were unaware of the predicate offense. The court granted Fernandez the liberty to approach the court at an appropriate stage, indicating that she may seek relief again during the trial proceedings. In an important ruling, the Orissa High Court has emphasized that higher educational qualifications alone cannot be grounds to deny maintenance to a wife. The court observed that unless there is a clear evidence of income or actual prospects of earning, it would be unfair to generalize that educated wives intentionally avoid working to burden their husbands with maintenance liabilities. Justice Gauri Shankar Satpathy made this observation while dismissing a revision petition filed by a husband challenging a maintenance order passed against him. The husband had argued that his wife, being a qualified MA LLB and working as a teacher and LIC agent, was not entitled to maintenance. He also contended that his now major daughter could not claim maintenance under Section 125 of the CRPC. Rejecting these submissions, the court upheld the family court's order directing the husband to pay 5,000 per month each to his wife and daughter, totaling 10,000 rupees from 2012. The court clarified that while Section 125 of the CRPC limits maintenance for children to minors, Section 20, Clause 3 of the Hindu Adoptions and Maintenance Act of 1956 entitles an unmarried daughter to claim maintenance until marriage, provided she cannot sustain herself. The ruling is a prototype for understanding how maintenance laws can play out in a variety of situations, holding nuance at its core. In another noteworthy development, the Supreme Court has issued notice on the wire's plea challenging the summons issued to its editor and deputy editor in a criminal defamation case filed by former JNU professor Amita Singh. The case stems from a 2016 article published by The Wire, which Singh claims falsely attributed to her the preparation of a dossier labeling JNU as a den of organized sex racket. Singh alleges that the publication did not verify the authenticity of the dossier and used it for monetary gain, thereby defaming her reputation. Senior advocate Kapil Sibal, representing the petitioners, argued that the summons should be quashed, citing the provisions under the BNSS. Justice Sundaresh, while agreeing to issue notice, remarked, "I think time has come to decriminalize all this," indicating the court's inclination to reconsider the criminalization of defamation. This case has seen several legal proceedings. In 2023, the Delhi High Court quashed the summons issued to The Wire and its editor. However, the Supreme Court reversed this decision in 2024 and remanded the matter for fresh consideration. In May 2025, the Delhi High Court again rejected The Wire's challenge to the summons, leading to the current appeal before the Supreme Court. The outcome of this case could have far-reaching ramifications on the judicial treatment of defamation laws in India, particularly concerning media freedom and the protection of individuals' reputation. In what could be a crucial legal development, the Supreme Court is set to examine whether the officers of the Hyderabad Cricket Association qualify as public servants under the Prevention of Corruption Act 1988. This issue arises from charges of corruption, conspiracy, and misappropriation related to the construction of the Rajiv Gandhi International Cricket Stadium in Hyderabad. The Anti-Corruption Bureau has alleged that the stadium's construction cost was inflated from an initial estimate of 31 crores to over 108 crores. Additionally, irregularities in ticket sales led to a 44 lakh rupees sales tax fine, and contracts for grounds and floodlights were awarded without following proper tender processes. The accused petitioners contend that the HCA is not a state under Article 12 of the Constitution and does not receive government aid along with its members who are not public servants. However, the Telangana High Court rejected this defense, finding a prima facie case that the HCA received government financial assistance through historical grants and notably a prime land lease at a highly subsidized rate. Citing precedents like Zee Telefilms Limited versus Union of India and BCCI versus Cricket Association of Bihar, which established that cricket governing bodies discharge public functions akin to state functions, the High Court held that the HCA's office bearers could be considered public servants under the Prevention of Corruption Act. The Supreme Court's upcoming examination of this issue could push forward the jurisprudence regarding governance of sports associations and the application of anti-corruption laws in such contexts. In an intriguing development, the Rajasthan High Court has granted bail to a 19-year-old college student accused of circulating sexually explicit material and blackmailing a 23-year-old married woman on social media. The court imposed a unique condition. The accused is prohibited from using any social media platforms for 3 years, whether under his real name or any fictitious identity. The complainant alleged that the accused edited and shared explicit content of her on social media to damage her reputation and disrupt her marital life. He also reportedly used his material to intimidate and blackmail her. In his defense, the accused claimed he was no longer needed for further investigation, had no prior criminal record, and pledged not to repeat such offences. Justice Ashok Kumar Jain, while granting bail, emphasized the need to protect the victim's safety and marital stability from the accused's notorious actions. The court noted that the accused had used multiple mobile phones and Instagram accounts to commit the offense. However, considering factors like the offense being triable by a magistrate, the stage of the investigation, the accused's age, and lack of criminal history, the court decided to grant bail with the stringent condition regarding social media usage. What do you think about the court's approach here? Rehabilitative or disproportionate? And in another controversy arising from the webs of social media, the Allahabad High Court has dismissed a petition filed by Bhojpuri singer and activist Neha Singh Rathore, challenging an FIR registered against her over social media posts relating to the Pahalgam terror attack. The FIR lodged in April 2025 accused Rathore of using derogatory language against Prime Minister Narendra Modi and Home Minister Amit Shah in her posts, suggesting that the BJP government was sacrificing soldiers' lives for political gain. The posts were made shortly after the Pahalgam attack, which the court noted as a critical factor. Rathore's counsel argued that her posts were protected under Article 19(1)(a) of the Constitution, which guarantees the right to freedom of speech and expression. However, the court observed that the language used in the posts was disrespectful towards the Prime Minister and Home Minister, and the content could potentially disturb public order. The bench emphasized that while freedom of speech is a fundamental right, it is subject to reasonable restrictions, especially when it concerns matters that could affect national security or public order. The court directed Rathore to cooperate with the ongoing investigation and appear before the investigating officer on September 26th of 2025. This ruling is important because it is indicative of what the judiciary's stance is going to be on balancing the right to free speech with the need to maintain public order and respect for constitutional institutions. And with that, today's edition of Courts Today is concluded. To access all the cases mentioned here and detailed coverage on more issues, you can visit www.livelaw.in and follow us on all our socials including YouTube and Instagram. I'm Devajit Das. Thank you for watching.